Hey there, future legal experts. Welcome to the deep concepts of Indian laws, where we dive deep into the fascinating world of law. Whether you're a student a professional or just someone curious about legal principles, you're in the right place. We break down complex concepts, dissect landmark cases, and explore how law shapes the world we live in, step by step, one topic at a time. So, grab your legal pads, hit that subscribe button, and let's get started.
Today's topic would be the concept of capital punishment. Capital punishment, also referred to as the death penalty, is one of the most controversial and debated topics in the criminal justice system globally. In the Indian context, it occupies a complex and often contentious position, with its legal framework shaped by centuries of tradition, evolving judicial interpretations, and moral debates surrounding its necessity and fairness. Despite calls for its abolition, capital punishment remains a legal penalty in India, but its application is limited to specific cases and governed by strict judicial scrutiny. The death penalty has a long history in India, dating back to the pre-colonial era. During British colonial rule, the Indian Penal Code, IPC, was introduced in 1860, written by the first Law Commission presided over by Lord T.B. Macaulay, and it provided for the death penalty in certain heinous offences. However, the use of capital punishment was considered a punishment aimed at deterrence and maintaining law and order under colonial rule. After India gained independence in 1947, the legal provisions surrounding the death penalty continued under the IPC, though the debate around its morality and effectiveness gained momentum.
The Constitution of India, adopted in 1950, does not explicitly prohibit capital punishment. Instead, Article 21 of the Constitution guarantees the fundamental right to life and personal liberty. But the Supreme Court has held that the right to life does not extend to the right to live in all circumstances, and the death penalty is constitutionally valid if applied in the rarest of the rare cases. This interpretation emerged from the landmark judgment in Bakhan, Singh v. State of Punjab, 1980, where the Supreme Court upheld the death penalty but set strict guidelines for its application.
Under Indian law, capital punishment can only be imposed for the most serious offences, particularly those that involve extreme violence or cruelty. The most common offences punishable by death include murder, terrorism-related crimes, and certain cases of sexual assault. The law mandates that before the death sentence is imposed, the court must be convinced that the crime falls within the rarest of the rare category. In Bashan Singh v. State of Punjab, 1980, the Supreme Court established the rarest of the rare doctrine, which meant that the death penalty should be applied only when the crime committed is exceptionally grave and when the alternative of life imprisonment is insufficient to meet the ends of justice. This principle was later reinforced in subsequent rulings such as Machi Singh v. State of Punjab, 1983, and Shivaji v. State of Maharashtra, 2003, which further narrowed down the circumstances under which capital punishment could be imposed. The judgment in Bashan Singh was a turning point in India's approach to the death penalty, as it introduced a bifurcated sentencing procedure. This procedure requires the court to first establish the guilt of the accused and then assess the appropriate sentence based on the gravity of the crime and the circumstances surrounding the offender's life, character, and intent. While the death penalty remains legal in India, its application is highly scrutinized. In practice, the number of executions has been significantly reduced in recent decades. According to data from the National Crime Records Bureau, NCRB, fewer than 5 executions are carried out annually in India, and the total number of death sentences imposed has been steadily declining. This trend reflects a growing reluctance among the judiciary to impose the death penalty and a shift toward alternative forms of punishment such as life imprisonment. The Supreme Court has also placed strong emphasis on fair trial procedures and the quality of legal representation in capital punishment cases. In Santosh Kumar Bariavi, State of Maharashtra, 2009, the court emphasized that the imposition of the death penalty must be based on the principle of proportionality, ensuring that the punishment is not excessive in relation to the offense. Additionally, the court has highlighted the need for legal aid to be provided to the accused, especially in cases involving indigent defendants who may not be able to afford competent legal counsel. In recent years, the court has become increasingly cautious in its approach to the death penalty. In Rajiv Gandhi assassination case, 2014, the Supreme Court commuted the death sentences of some of the convicts, citing the long delay in executing the sentence and the psychological impact on the prisoners. This judgment added another layer of complexity to the debate, highlighting the question of whether prolonged incarceration on death row constitutes a violation of the right to life and dignity. The debate over capital punishment in India is not limited to legal principles alone. It is also deeply entwined with ethical and human rights concerns. Opponents of the death penalty argue that it is inherently inhumane, irreparable in the case of judicial errors, and disproportionately affects marginalized communities. The possibility of executing an innocent person is a significant ethical dilemma, and this risk has led to calls for the abolition of the death penalty altogether. Human rights organizations, including Amnesty International and Human Rights Watch, have consistently called for the abolition of the death penalty in India. They argue that it does not act as an effective deterrent to crime, and that the resources spent on lengthy trials and appeals could be better utilized in addressing the root causes of crime, such as poverty, illiteracy, and lack of access to justice. Furthermore, there is a growing concern about the death penalty being disproportionately applied to certain groups, particularly the poor, minorities, and those from disadvantaged backgrounds. Studies have shown that individuals from lower socioeconomic classes are more likely to receive the death penalty, raising questions about equality and fairness in the criminal justice system. Now, to conclude, it can be said that capital punishment in India continues to be a subject of intense debate, balancing the need for justice, deterrence, and human rights. The legal framework surrounding the death penalty has evolved over time to ensure its application is restricted to the rarest of the rare cases, with multiple layers of judicial scrutiny. While the Indian judiciary has moved toward more cautious application of the death penalty, the ethical and human rights implications remain a central concern. As India grapples with questions of fairness, justice, and human dignity, the future of capital punishment will likely continue to be a topic of profound societal reflection and legal evolution.